We're live.
Excellent. Thank you, Sandy. Well, good afternoon, everyone. Welcome. Today is Thursday, January 13th. Welcome to the Judicial Proceedings Committee. Today, we have 10 bills on the docket, and we'll just go in sequential. Actually, we won't go in sequential order. We'll start off with Senate Bill 176. We'll go to 218, 208, 172, 189, 216, 203, 214, 198, and 212. So with that, we'll start off with Senate Bill 176. And Chrissy, there you are. I see you up there. The floor is yours.
Secretary Jim Ports is going to actually kick it off, and then I'll testify. Jim, I think you're on mute.
You're on mute here. Let's unmute you here.
There we go.
There you go.
Okay, there it goes. It wouldn't let me do it in the lower left. So thank you very much. Good afternoon, Chair Smith and Vice Chair Waldstreicher, and of course, members of the committee. For the record, I'm Jim Ports, Secretary of the Maryland Department of Transportation, and I want to thank you for allowing me the opportunity to introduce Senate Bill 176. As you know, at MDOT, we are committed to delivering safety and security for all Maryland's roadway users, including infants and toddlers, who are some of our most vulnerable users. As the former Deputy Administrator of the National Highway Traffic Safety Administration, NHTSA, as it's referred to, highway safety is extremely important to me, and I'm proud to support this important safety legislation to help us reach our goal in Maryland of 0 fatalities. Senate Bill 176 would require that children under 2 years of age ride in rear-facing child safety seats, so long as it complies with the manufacturer's weight and height limitations. And as you know, we take our responsibility for protecting all of Maryland's traveling public very seriously. And with this legislation, Maryland would be reinforcing recommendations of the American Academy of Pediatrics and, as I mentioned, the National Highway Traffic Safety Administration by joining nearly 20 states in passing similar legislation. For these reasons, I respectfully request the committee grant Senate Bill 176 a favorable report. And now I'd like to turn it over to MDOT MVA Administrator, Christine Nizer. Thank you again.
Excellent. Thank you, Mr. Secretary. And there you go. Mr. Nizer, there you are.
Great. Well, thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. Great to see you. Happy New Year to everybody. Here today in support, again, Chrissy Nizer, MDOT MVA Administrator, and also serve as the Highway Safety Representative for the state of Maryland. Here in support of Senate Bill 176, and as Secretary Ports outlined, it would add some specificity to our current child passenger safety law, which does already require that any child under the age of 8 years be transported in a child safety seat unless the child is 4 feet and 9 inches. This bill provides further clarification that I think would be helpful to parents on a topic that frankly can be at times confusing. The statistics show that over the past 5 years, we've averaged 12 fatalities and 3,000 injuries in motor vehicle crashes involving passengers under the age of 13. And as the Secretary said, we certainly want to protect all of our roadway users, but certainly our most vulnerable ones especially. It is consistent with recommendations made at a national level, and we know that the physics frankly says that children who are ride forward-facing, their heads don't have the appropriate protection. They're larger and heavier than they are in children who are older as well as adults, and being thrown forward possibly can provide or cause very serious spinal as well as head injuries, which is significant for that young developing child. Also, the back of the seat is able to absorb a lot of the impact if a crash occurs. And so, having a child rear facing for as long as possible, frankly, is the recommendation, but especially up to age 2. And that's why we want to be consistent with that. I do also want to point out, Secretary Ports mentioned that in the legislation, it includes a provision that is consistent with manufacturer recommendations. Most child safety seats are good for children who weigh up to 40 pounds. However, if there was a child who was under age of 2 but over 40 pounds, that parent could move the children to be front facing because it is consistent with the manufacturer recommendations. We want to make sure that we gave parents that option. With that, I'd be happy to answer any questions, and I would ask for the committee's favorable report.
Excellent. Thank you, Administrator Neiser. I look around the room. I see that Senator West has a question. Senator West. Oh, hold on. There you go.
Oh, yeah. Thank you, Mr. Chair. First of all, I want to acknowledge the presence with us this afternoon of Senator Huff. And it's nice to see him. And he looks healthy. We hope he is healthy. And we look forward to him getting back to join us soon. Second, Ms. Neiser, I really want to thank you for giving me the opportunity to talk about this bill before session. And I just wanted to point out that in answer to one of my questions, Ms. Neiser indicated that these days most child seats are designed so they can either be affixed to the car facing forwards and backwards. So a seat which is heretofore has been facing forwards can be just readapted to face backwards, and the owners won't have to go out and buy a second child seat. That was relevant information, I thought, and I just want to make sure the committee is aware of that. Thanks.
That's right. Thank you, Senator West. The seats often, as I said, they're good up to 40 pounds, and sometimes parents don't know exactly what the standards are. So if they had moved the child safety seat to a forward-facing position, all they would need to do is readjust that, assuming the child is under 2. And again, really the recommendation is stay rear-facing as long as possible, because the physics hold true about the head being larger as that development continues, but certainly up to the age 2, consistent with best practices. So thank you for that information.
Thank you, Senator West. All right, next we have Senator Castley. Senator Castley, here you go.
Thank you, Mr. Chairman. Good to see you all. Secretary Ports and Chrissy, good to have you back. Looking at the bill, it says that it specifically says that you have to comply with the applicable federal regulations until the child reaches the weight or height limit specified by the manufacturer of the child safety seat. So, a police officer looks in and checks. Are they posted on the seat? How will an officer know whether you comply with manufacturer's recommendations?
That's a great question, Senator Castley. Yes, they are required to post the manufacturer the weight restrictions right there on the child side of the child safety seat. So a law enforcement officer would be able to readily see that information. Just like vehicles are tested, child safety seats go through similar tests, and that's why all of that relevant information is required to be posted for ease of sight.
But the weight limit of the seat, does it also post the weight limit? I'm sorry, whether it should be forward or rear facing?
So yes, it will specifically say up to a certain weight that they can be forward facing, and then that specific information is right there, because often some of those seats can actually transition into booster seats as well, obviously for older children, but many of them now are transitional seats that move from cradling that infant really to that older toddler age.
Yeah, I'm just anticipating an immense amount of public input in letters and email coming on this. I mean, a lanky two-year-old kid will likely not be able to sit facing rear. His feet will be pushing against the back of the seat and his knees under his chin. I would anticipate for a lot of your taller kids, even if they don't meet the weight requirements. So we'll just sit back and watch and see what the public has to say. Thank you.
Sure, and that's a good point. We actually looked at that before we introduced the legislation, and the recommendations, according to the pediatrics, is that it's actually more comfortable for a child because their joints aren't developed in the same way as us. And I'm sure you've seen a young child and they can contort their legs in ways that would be incredibly uncomfortable for us to do so. And that's because their joints aren't yet developed. And so, them crossing their legs or sitting in a way that the legs are bent is actually much safer than them being in a position where they'd be rear facing and then again facing that potential of the neck and head injuries. So something certainly we're definitely conscious of, but that's what the research has shown.
No, I got it. I mean, I'm just looking for that tall 2-year-old girl with her knees bent up to her chin for the 6-hour drive heading south to on vacation. But we'll see what the public has to say. Thank you very much. Appreciate it.
Thank you.
Actually, that's Senator Castley. It's interesting you said that, because I've at drill this past weekend, I have a Navy buddy. Our children are the same age, but he is 6'7", and his children his twin girls are tall, very tall. And he said, look, common sense prevails. I had to turn that seat around when they were 2 because they're too long. So you do bring up an interesting point. So I guess we'll talk about it a little more. But
Yeah, thank you. Good to see you all.
Thanks. All right. Looking around the room, if there are any other members of the committee that have questions. All right. Thank you, Mr. Secretary and Administrator Nizer. Thank you very much. And with that, that'll conclude the hearing for Senate Bill 176. We'll now move on to Senate Bill 218, and we'll start off with the Secretary. Mr. Secretary, the floor is yours.
Okay. Well, thank you again. Good afternoon, Mr. Chair and Vice Chair and members of the committee. For the record again, my name is Jim Port, Secretary of Maryland Department of Transportation. And thank you for allowing me the opportunity to introduce Senate Bill 218. As you know, the COVID-19 pandemic has repeatedly demonstrated the need for flexibility. And as we strive to provide critical services while prioritizing health and safety for all Marylanders, Senate Bill 218 would allow for the M.MBA to improve on its premier customer service by authorizing driver's license and identification card extensions for up to 2 years, opposed to the current 90 days. And quite frankly, Mr. Chair, as a former Marine, I recognize that this would help active duty members as well as others, which I'm sure Administrator Nizer will share with you. As you know, M.MBA is dedicated to providing premier customer service, and passing 218 is another step forward in that effort. For these reasons, again, I respectfully request the committee to grant Senate Bill 218 a favorable report. And now I would like to turn it over to M.MBA Administrator Christine Nizer.
Thanks again, Mr. Chairman, members of the committee. Christine Nizer, M.MBA Administrator, in support of Senate Bill 218. Certainly, COVID has had some tragic consequences for our state and our nation, but it's also allowed us to re-examine some of the procedures and some of the laws that we have in place. As the Secretary outlined, we currently have the ability to issue a 90-day, two 45-day temporary licenses for a total period of 90 days for Sorry, did you hear anything I said?
No, you went mute for about 5 seconds there.
Okay. So currently there's the ability in statute to issue 2 45-day temporary licenses for a total period of 90 days. What we're asking authority for is to extend that to 2 years under certain circumstances. So we laid out in statute that that would cover our military members serving overseas. Their licenses are still good, but we know that certain countries require that license to be in good standing. It would also cover individuals who are attending college out of state. It would cover individuals who may be out of state for personal reasons for an extended period of time. I helped a customer who unfortunately had a child who was going through chemotherapy and had to come home after 90 days to get a valid license. Just, not something we want to ask our customers to have to do during those challenging times, as well as individuals who may have immune compromised systems or medical issues. And even after our extensions expired for our licenses, which were in place for some time, they were then required to come in within a period of 90 days. And so while we were as creative as possible in working with folks to get those licenses in good standing, this kind of extension would allow the ability to do that in a really flexible way. We just recently deployed our new Customer Connect system related to driver licenses, and customers can actually now for the first time request that extension right online. So making it as convenient as possible. They don't have to call, they don't have to get to the right person to make that happen. Again, it's all about that focus on premier customer service. And when we looked around throughout the country to see if there were other measures in place that might be something that we could emulate, we found that Virginia had this 2-year extension. So we felt like that was a good balance, giving a little bit longer than the current 90 days, but not extending that period for too significant a time frame. So with that, I would ask for a favorable review and be happy to answer any questions.
Well, thank you, Administrator Nizer and Mr. Secretary. Looking around the room, are there any questions from the committee? Okay, and with that, that'll conclude the hearing for Senate Bill 218. Thank you both very much.
Thank you.
Good to see you guys.
Good to see you.
Remotely. All right. We'll now move on to Senate Bill 208, and we'll start off with Mr. Wiedefeld. Are you there? think here we go. I'll unmute you. I found you, and
Yes, I am here.
excellent. There you go. How are you, sir?
Very good. Thank you so much.
Very good.
Can I start?
The floor is yours. Yes,
Great.
please.
Thank you. Thank you, Mr. Chairman and members of the committee for allowing me to testify today. My name is Paul Wiedefeld. I am the General Manager and CEO of the Washington Metro. I thank the Maryland Department of Transportation for backing this critical legislation, and also thank Senators Wald, Stryker, and McCray for the past sponsorship of this bill. When a transit operator is assaulted, it not only jeopardizes the safety of the employee, but the fellow riders and the public at large. The offenses our operators encounter vary and include spitting on operators, striking operators with closed fists, sticks, bricks, and poles, and assaults with deadly weapons. You will hear from Mr. James Washington, a Metro bus operator who was a victim of assault last year. Unfortunately, Mr. Washington is not alone, and the number of assaults on the transit employees is on the rise in Maryland. As provided in my written testimony, assaults on station managers, train operators, and bus operators in Maryland has increased from a total of 16 in 2020 to 37 in 2021. Sadly, the trend is continuing in 2022. Just 2 days ago, a Metro bus operator was pistol whipped, and the assailant attempted to commandeer the bus with passengers in it. Metro has taken many actions to deter such assaults. All Metro buses are equipped with security cameras and plexiglass shields to protect the operator. Additionally, we deploy undercover Metro Transit police officers and dedicated to riding buses, and have additional scout cars patrolling troubled routes. Our actions alone, though, are not enough. We firmly believe that the actions we are taking, coupled with the additional penalties provided by this legislation, will reduce these incidents in the future. For Mr. Washington, for his Metro colleagues, for all the transit workers in Maryland, and for the safety of the public at large, I urge you to vote in favor of Senate Bill 208. I'd be glad to take any questions, sir.
Excellent. Thank you. We'll hold off until the end. Actually, Senator Castley, was that a hand you had up? All right, let's go ahead and do this. We'll do this right now, and then we'll keep moving on with the panel. Go ahead.
So my only question is defining the public transit services. Just curious on the technical side, what this includes, but because I couldn't find a definition of public transit service. Maybe this is somewhere in the code and you can give us a reference to that.
I will work with the department. I think the department may have that at hand, MDOT.
Thanks. Okay. Thank you, Mr. Chairman.
Excellent. Thanks. And Senator Sidner, I saw you nodding. Was that the same question you had? Got it. All right. Thank you, Mr. Wiedefeld. We'll move on next to Robin Buddish. Robin here?
Yes, good afternoon.
Oh, there you are.
Yes,
Please proceed. The floor is yours.
thank you so much. My name is Robin Budish. I am Director of Transit Choices. We are an organization that advocates for safe, equitable, reliable public transit in Baltimore City. I am testifying today because any assault on a public transit operator, in our opinion, is completely abhorrent. These are frontline essential workers who are committed and dedicated to their work. Any assault on such individuals, aside from the personal pain and losses they suffer, both short and long term, it absolutely results in affecting reliable, efficient public transit service. And by that, I mean absenteeism rises, they have to pull buses off routes, and the end result is people that are very transit dependent on buses. What they experience is a lack of public transit to schools, to jobs, to opportunities, healthcare, and even healthy food. Thank you very much.
Excellent. Thank you very much. And with that, we'll move on to Secretary Ports. My apologies. I didn't see you were farther down on the alphabetical list, so my apologies. Mr. Secretary, you're up next.
That's not a problem, Mr. Chairman. You know, it's a lot easier when we're in person, right? But with these virtual meetings, it gets a little more difficult. But again, thank you, Mr. Chairman and Vice Chair Wald, Stryker, and members of the committee. For the record, my name is Jim Ports, Secretary of Maryland Department of Transportation. And however, Secretary is one thing, but it may be even more important that I'm speaking from this issue as a former administrator and CEO, having run a locally operated transit system for nearly 7 years. So I know transit extremely well. And I want to again thank you for allowing me the opportunity to introduce Senate Bill 208. And at MDOT, we're incredibly grateful for the hard work of so many dedicated individuals who operate our buses, mobility vehicles, and quite frankly, other transit services. You know, these individuals have been working through the pandemic and continue to provide critical services to Marylanders, such as driving our children to school, transporting the elderly to medical services, and guaranteeing that so many people are able to get it to their places of employment, including, quite frankly, hospital workers and nurses. Senate Bill 208 would protect these workers by increasing the penalty to a second-degree felony assault for anyone who purposely assaults a transit operator. These operators continue to demonstrate every day that they're critical frontline workers, and this legislation would bring them in line with protections of other frontline workers, such as law enforcement officers and firefighters. For these reasons, I respectfully request the committee to grant Senate Bill 208 a favorable report. And now, if you don't mind, Mr. Chairman, I'd like to turn it over to MDOT MTA Administrator Holly Arnold.
Excellent. Yes. Ms. Arnold, floor is
Hi,
yours.
thank
Welcome.
you. Thank you, Secretary Ports. Good afternoon, Chair Smith, Vice Chair Wallstreicher, members of the committee. For the record, I'm Holly Arnold, Administrator of the Maryland Transit Administration. And thank you for allowing me the opportunity today to introduce and support Senate Bill 208. MTA is exceptionally grateful for the service of every one of our bus, light rail, metro subway, and mobility operators. These extraordinary women and men provide exceptional service to the residents of Maryland every day, sometimes at great personal risk. Throughout the COVID-19 pandemic, our operators have served a critical role, getting riders to their doctor's appointments, to the grocery store, and even to their frontline jobs at area hospitals. However, since 2013, an average of 50 assaults against MTA operators have been reported each year. For instance, in 2020, there were 46 assaults committed against our operators. The impact these assaults have on our operators is understandably very significant. They're both physical and mental impacts when an operator is assaulted. Of course, with any assault, there's the risk of serious bodily harm that could require medical attention. But any threat with a weapon, even without the physical injury, can be just as damaging as a physical assault. There's significant psychological toll on our operators when this happens. Our operators are frontline heroes. They've provided an essential service to the residents of the state throughout one of the most difficult periods of our recent history, and we owe them our support. And an assault against one of our employees is not only a danger to their personal well-being, but it impacts their ability to do their job, so that so many across the state rely on them for. So while our primary objective of this bill will always be to protect our frontline employees, I'd be remiss not to mention the larger impact to our service. When an operator is assaulted, we need to pull them from service to ensure that they receive the care that they need and to take a formal report of the incident. That means that a bus or train is canceled, and that can result in a significant delay for our customers who rely on our service. Senate Bill 208 will protect our operators and the riders they serve by increasing the penalty to second-degree felony assault for anyone who purposely assaults a transit operator. This legislation will bring them in line with protections of the other frontline workers, thus recognizing the important frontline work that they provide. Before I close, I'd like to take a moment to remember the operators who were murdered in the line of duty over the last few years. Marcus Parks, Frankie Duckett. They were frontline heroes. We all owe them a debt of gratitude. And we believe that the increased penalties in Senate Bill 208 will be a strong deterrent against the type of unconscionable violence that has claimed the lives of these two operators and impacted many more. So it's for these reasons that I respectfully request the committee grant a favorable report on Senate Bill 208. I'm happy to answer any questions, and thank you again for your time this afternoon.
Excellent. Thank you very much. And I see Senator Huff has a question, but Senator, I'm going to hold off to the end of the panel, and then I got you. All right, next we have Brian Weibel. You're up next. There you go.
Thank you for the opportunity to testify today on behalf of the Amalgamated Transit Union, the largest labor organization representing transit workers in the United States and Canada. ATU today has more than 19,000 members in Maryland and the Washington, D.C. area alone, including the workers at Maryland Transit Administration, the Washington Metropolitan Area Transit Authority, as well as workers at private transit companies throughout the state. ATU Local 689 and Local 1300 fully support Senate Bill 208, which would add certain public-facing transit workers to the list of protected professions, one that includes law enforcement officers, firefighters, and emergency medical workers. Assaults on these categories of workers would result in stronger penalties, hopefully serving as a deterrent. We strongly urge the General Assembly to pass this legislation as soon as possible. Due to the nature of their employment, which includes handling money, dealing with complaints, working alone and late, and enforcing regulations, transit employees are vulnerable to horrific criminal acts, and they are confronting all of this while trying to safely steer their vehicles through traffic. Not even 72 hours ago, a WMATA bus operator was pistol whipped, forcing them to go to the hospital. In Baltimore, 3 transit workers were killed last year alone. WMATA's own data shows a concerning rise in attacks on transit workers in just the last year. The current law dealing with this issue, which only applies to MTA and not WMATA or any other properties, states that it is illegal to obstruct, hinder, interfere with, or otherwise disrupt or disturb the operation or operator of a transit vehicle or railroad passenger car. Unfortunately, the penalty is only a misdemeanor subject to a fine of not more than $1,000 for each offense. Some may argue that laws that make it more of a crime to harm some people as compared to others are undemocratic. However, in most states, legislators have come to understand that when transit workers are assaulted in the course of performing their duties, the safety of every individual on board the vehicle is placed in immediate jeopardy. ATU commends the administration for the introduction of this critical legislation. This bill, which is long overdue, is unfortunately necessary.
Thank you, Mr. Weibel. Next, we have John Dolosky. Here, is John here? There you go. Gotcha.
Chair Smith, Vice Chair Waldstreicher, and members of the committee, thank you for allowing me to testify in support of Senate Bill 208. My name is John DeKlusky. I am the Executive Director of the Transportation Association of Maryland. We represent 104 transit agencies and organizations across Maryland, from Garrett County in the west to Ocean City in the east, with Montgomery County in the middle. I won't repeat what our other panelists have already said in favor of this bill, but just to add a couple more data points here. Assaults on drivers have increased 4-fold since 2009. Over half of our members reported that their drivers suffered multiple assaults in the previous year. 3 out of 4 described their drivers as regularly experiencing threats and intimidation. In one case, theft of a bus's book of bus passes during an assault was more heavily punished than that driver being beaten with his own radio. Drivers are strapped in and alone in their driver's seat. They are uniquely vulnerable to assault. During a time when many agencies are struggling to adequately staff their services and are competing with many private sector transportation jobs, it is important to do a better job of protecting our frontline transit workers while sending a strong message to passengers that assaults will be punished to the fullest extent of the law. Therefore, we respectfully urge the committee to vote for a favorable report on Senate Bill 208.
Thank you very much. And next, we'll move on to DePaul Nyber. I think I saw you. There you are. How are you? Oh, one more time. Here you go.
Here we
There you
go. Thank you, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is DePaul Nibber. I'm representing the Maryland Association of Counties, also known as MACO. We urge a favorable report for SB 208. For 2022, MACO has prioritized protecting our civil service workers and has even made it one of our 4 priorities initiatives. Our counties want to ensure the safety of frontline workers whose careers require that they interact with the public. This includes school bus drivers whose work is incredibly demanding. Right now, as many of you are aware, we're experiencing a statewide shortage for qualified drivers. SB 208 would ensure their safety and reinforce the state and our local government's commitment to these workers and their invaluable role in serving our communities. Once again, we urge a favorable report for SB 208. Thank you.
Thank you, Mr. Nibber. We'll now move on to Mr. Rouse, James Rouse.
I don't think he's here.
Okay, so we won't move on to Mr. Rouse. We'll go on to Mr. Washington, James Washington.
I'm here.
There you go. You're live.
Okay. Mr. Chairman, members of the committee, thank you for allowing me to testify today. My name is James Washington. I live in Oxon Hill, Maryland, and I'm employed as a Metro bus operator out of the Landover Bus Division. I am here to urge you to support Senate Bill 208 and to share my own personal account as a transit operator. On the night of August 30th, 2021, I was operating the 83 line heading to Cherry Hill Park. I was ahead of schedule, so I parked at the bus bay, waiting to enter the campground. I had no altercations with anyone on my bus that day. My driver's side window was open, and I heard a male voice shout an explicit to me, and then urine was thrown in my face, making contact with my forehead, eyes, nose, mouth, and clothing. And to this day, I still have side effects from this incident, but I do realize I have a family that depends on me. Transit police did respond to take a report, and MTS respond to treat and rinse my eyes. I appreciate the assistance that these first responders provided to me. I'm hoping and praying in this legislation that if a first responder is ever assaulted in Maryland, the assault could be classified as a felony. I think this is appropriate. First responders are public servants going about their job, and we are required to go wherever the job takes us, serving any and all communities. The exact goes for all transit workers. We are essential workers serving our communities, and our job requires our interaction with all members of the public. This legislation is not just about protecting transit operators. My assault happened to me when I was parked, but that's not always the case. An assault against an operator moving transit vehicle could be a very extreme and hazardous for all passengers and even motorists. I hope you all agree that protection provided under Maryland law to prevent assaults on first responders should be extended to cover transit operators. On behalf of myself and my fellow transit operators across the state, I thank you for your time, and I urge you to vote in favor of Senate Bill 208.
Thank you, Mr. Washington, and thank you for the good testimony there. Just a reminder to the guests that when you're testifying, you have to be on camera and visible on camera. So thanks. I know this is our first hearing of the session, but just a little friendly reminder. We had and this is not personally directed to you, Mr. Washington. We had an infamous repeat offender last year. So just want to make sure that everyone's on notice this year. So thank you very much, Mr. Washington. All right, we'll now move on to questions. I see that I remember that Senator Huff had a question, so we'll start off with Senator Huff and we'll go to Senator Sidnor.
Yeah, my question is, whenever we look to enhance a penalty, and in this case, going to a felony, which obviously is very serious, carries a lot of collateral consequences, and that's a very serious move to do that. There was 46, you said last year, assaults on public transit employees. My question is, how many people were convicted, and do we know what their sentences were in those cases?
Senator Huff, who would you like to direct that question to?
Anyone that could answer that.
Okay. If you're a guest and you think you can answer that, if you're a witness, please raise your hand and I'll unmute you. All right, here we go.
Sorry, I'm not a Zoomer, so I don't know how to raise my hand in the Zoom function, but that worked. So I don't have the specific details on the convictions on those. Our MTA police do proceed in prioritizing those for investigation, so I can get you the specific details on that for those 46, but I don't have that right now. So we'll follow up and send that to your office.
Because what I'm curious is that the two instances that were brought up that I heard about, it sounds like there were either not convictions or they were very light sentences. And in Maryland, we actually have one of the strongest assault laws in the whole country. Carries up to 10-year penalty. So if we have 40 people that got the 10-year penalty, well, then I guess there's a case that we need to strengthen the penalty. But if of the 46, if they're not barely being charged, I would question why raising it to a felony would serve as a further deterrent.
Yeah, we're happy to get you that information. I mean, I think we just want to recognize the important frontline work that our operators do. One assault is too many. And so anything that we can do to have a tool in our toolbox towards a deterrent is something that we're looking to do.
I understand that. And I don't want to take away from the good work that they're doing by all means, but at the same time, we're going to have bills in from nurses and doctors and other people that do very good work too as well. And they're going to ask for the same thing to be a felony. We'll probably have those in this year. And so you just got to make sure that the punishment fits. So I look forward to seeing that data. Thank you.
Muted myself. Excellent. Thank you, Senator Huff. We'll now move on to Senator Sidnor.
Thank you very much, and good afternoon. I too will be interested in that material that the senator had asked about. I think last year when we heard this bill, I think some of the concern was certainly around what that definition of provision of public transit services meant, because last year, similar to this year, a lot of the testimony is towards transit workers as their operating vehicles. I think Mr. Washington just testified that he was assaulted while not necessarily driving the vehicle, but I think from his testimony, it was my assumption that the vehicle was parked. And again, I think I mentioned last year that my mother was a transit driver, and at one point she was assaulted with a snowball that hit her in the face as she was letting a passenger over. Now, with that said, I think there's a distinction between transporting and driving the vehicle and someone being assaulted that could possibly kill everyone on that bus, as what happened, I believe it was in China, where a bus driver was assaulted and the bus ended up going off over a bridge. And someone who happens to be a bus operator, train operator, light rail operator, but maybe the vehicle is at a standstill and the passengers' lives aren't in danger. Ms. Arnold, would you mind speaking to that? I mean, I see a distinction, but with this bill wouldn't make that distinction, not unless this whole definition of what the provision of public transit services would.
Yeah, so we recognize it's a little bit of a gray area. Transit service is defined in code as the transportation of persons and their packages and baggages of newspapers, express and mail, and regular route, special or charter service by means of transit facilities between points within the district. So there's a definition there. The way that we read that is that anyone who's engaged in providing public transit service, whether those folks on the bus, whether they're at a layover, would be included in that. And so we did have the specific definitions there of the bus operator, train operator, light rail operator, paratransit operator, station attendant, to specifically call out those roles. And I do recognize, injuring someone while they're operating is a little bit different than, sitting at a layover. I think one of the things that we really want to recognize, though, is, even a bus operator who's assaulted while they're on a layover, it's going to have a huge impact to the service that they provide, right? Like if that operator isn't there to provide the service, that means that the riders are waiting. They're not getting to work. The nurses aren't getting to the hospital. Anyone who depends on that service is going to be left in the cold because our operator isn't there, besides the fact that they've just been assaulted.
All right, thank you, Senator Sidnor and Ms. Arnold. Looking around the committee for additional questions. Seeing none, that'll conclude the hearing for Senate Bill 208. We'll now move on to Senate Bill 172, and we'll start with Secretary Abed. Are you in the room, Mr. Secretary?
Yes, I'm here.
There you are. Good to see you. Welcome.
Great to see you, Mr. Chairman, and Vice Chair Waldstreicher, members of the committee. I'm Sam Abbott, Secretary for the Department of Juvenile Services, and I'm here in testimony or in support of Senate Bill 172. It's a very simple bill, so I'll just quickly describe what the bill is, which is to remove the Carter Center from the list of committed facilities from within the code. That's a facility that has closed. And remove the word or the term train from the services provided in DJS operated facilities. This is a term that is redundant. We have language in the code that says that we would educate youth for careers, jobs, or workforce. And so we would ask that that word be removed as well. So it's essentially a cleanup bill. It does do some cleanup in the code so that it reflects what is our reality. But I think also this bill is something that reflects our values at DJS, as well as our ability to execute on those values. And the value that's represented here is one that we've talked about, or I've talked about to this committee many times in the past, which is only to use incarceration when necessary to protect public safety. That's the value that we have held for a number of years here. And while I think that's something that we can all get behind, values alone don't move the needle and don't get the job done. You also have to have a great team to implement those ideas. And DJS is blessed to have an experienced team of professionals who embrace the challenge of reform. And all of their efforts have resulted in our committed populations declining by 79% since 2015, and is what makes this bill something that we have to do. So I would urge a favorable report on Senate Bill 172 to align the list of committed facilities with our reality, but also to acknowledge that this item represents significant progress in terms of outcomes for our youth. Thank you, and I'll be happy to take any questions.
Excellent. Thank you, Mr. Secretary. So we have a question from Senator Castley.
Thank you, Mr. Chairman. Hi, Mr. Secretary. Good to see you. I'm just, you're sort of concluding your remarks. Kind of, I suppose I should be reading more into this bill. So the J. Dewey's Carter Center, when did that close and why?
That closed a couple of years ago. The Carter Center, we've had very few girls in our system, and we continue to have few girls in our system. And at the time, we were operating that facility with a very low average daily population, under 5 kids. And so we've consolidated that program into another program. That's why it closed.
So I guess my question is really not, I'm not sure what you were sort of editorializing there on a grander scale, which don't seem to relate to this bill then at all, because all this bill does is take the Carter Center out, which is already closed for 2 years, and takes training out, because I guess the Carter Center was the only place that trained him, and all these places are doing training, which I guess I should probably find interesting. But I just do want to comment on your note that the detentions are down again. Of course, it also be the reverse side of that, and note that juvenile violent crime is up through the roof. So not sure if we're going to call that a rousing success and pop the champagne corks when, I mean, certainly the incarceration rates going down and crime rates going down, that's a success. When I see incarceration rates, detention rates going down, and crime going up, I would hardly think that's a success, but thank you for coming in.
All right, thank you, Senator Castley. Mr. Secretary, do you want to respond, or you're okay?
Well, I would just say that while the rates have gone down for incarceration, the crime rates for juveniles have not gone up and up and up. I think that there has not been an increase in crime rates, and I think that's one of the big successes in our goals to reduce incarceration. So I'll just leave it at that. Thank you, Mr. Chairman.
Excellent. Thank you, Senator Castley. Do you have another question?
Yeah, look, I'm sorry. I just sit here in disbelief. The suggestion that juvenile violence is not up. I'm sorry, Mr. Secretary. You can only come to that conclusion if we redefine violence, if we redefine juvenile, if we redefine justice, which I guess is what we're out to do. But the suggestion that violent juveniles are not seriously impacting the communities, I find quite frankly preposterous. But thank you. Appreciate you coming in today.
All right. Thank you, Senator Castley. Looking around the room for further questions. All right, seeing none, that'll conclude the hearing for Senate Bill 172. Mr. Secretary, thank you very much for coming in. We'll now move on to Senate Bill 189, and we'll start off with Ms. Scheck. Is she here? There you are. The floor is yours.
Thank you. So good afternoon, Chairman Smith, committee members. Thank you for having me here today to testify in support of Senate Bill 189. For the record, my name is Heather Scheck. I'm the Director of Governmental Affairs at the Department of Health. I'm also joined by my colleague, Lisa Guy. She's sitting next to me, which is why we're masked. She's the Chief of the Enforcement Division of the, Chief of the Enforcement Division at the Office of Controlled Substances Administration. And she'll be available for any questions the committee may have. Senate Bill 189 is a Department of Health departmental bill, and I would like to thank you, Mr. Chairman, for sponsoring it. And this bill is, it will update the state list of controlled dangerous substances to align Maryland law with federal regulatory changes to the federal list of controlled dangerous substances. MDH is required by criminal law section 5202 to make these updates regularly. So while I would hesitate to call it a technical amendment, it is a statutory requirement for the department to update our list annually to align with the feds. These schedules are used by the department to ensure that CDS registrants are operating in compliance with the most recent and relevant versions of the scheduled drugs. They're also used by law enforcement agencies to charge and assess penalties for criminal actions involving controlled substances. So, as I mentioned earlier, this is a statutorily required amendment to the bill. The Department of Health is in full support of it, and I would respectfully request a favorable report from the committee. So with that, I will keep it short and sweet and happy to take any questions.
Excellent. Thank you, Ms. Scheck. Look around the committee for questions. Seeing none, that's it. Thank you very much.
Perfect. Thank you.
Thanks a lot. With that, that'll conclude the hearing for Senate Bill 189. We'll now move on to Senate Bill 216, and we'll start off again with Mr. Daniel Katz. Daniel Katz, and then Ms. Scheck, you're up next. There you go.
All right, thank you. Chairman Smith, members of the committee, my name is Dan Katz. I'm the director of the Maryland State Police Forensic Sciences Division. I'm here today to express my support for Senate Bill 216, which transfers the responsibilities for the ante-mortem blood and breath test programs in support of impaired driving investigations from the toxicologist under the Post-Mortem Examiners Commission to a newly created toxicologist under the Maryland State Police Forensic Sciences Division. This is a mutually beneficial arrangement for both the Office of the Chief Medical Examiner and the Maryland State Police. The OCME post-mortem toxicology operations continue to be overwhelmed due to the ever-rising number of autopsies requiring toxicology results, and removing this responsibility will offer them some relief. Meanwhile, the Department of State Police toxicology operations are in the midst of expansion of our technology, staffing, and facilities to better meet the needs of our customers. In order to ensure long-term success, it is imperative that we have our own toxicologist to guide us forward, and that our toxicologist specializes in ante-mortem forensic toxicology rather than post-mortem forensic toxicology. For the reasons mentioned, the Department of State Police requests a favorable report for Senate Bill 216. Thank you.
Thank you, Director Katz. And Ms. Scheck, you're up next.
Thank you. Again, for the record, my name is Heather Scheck, Director of Governmental Affairs at the Department of Health. This is another Maryland Department of Health departmental bill. So again, Chairman, thank you so much for sponsoring. As Mr. Katz said, this bill has been a collaboration between the two departments, and we do believe it will be mutually beneficial. I won't go over what it does because Dan just talked about that. But I just want to give a little bit of history that I think might help the committee understand why this change would be necessary. So currently, the state toxicologist is in the office of the chief medical examiner, and the state toxicologist is responsible for the oversight of the toxicology program. This oversight is a legacy from 1962. At which time the OCME was the only lab capable of performing these toxicological analyses. And at that time, the responsibilities of the state toxicologist were almost exclusively limited to the breath alcohol testing program. But since that time, in the last 60 years, the program has really expanded to include blood alcohol and drug testing. And that's almost doubled the responsibilities under the program. And this type of oversight arrangement is really unique. We could not find any other DUI lab in the country that has a setup like this, in that the oversight by the oversight is not by a toxicologist who is not in the direct chain of command of the laboratory. So in this instance, the OCME toxicologist is overseeing the chain of command of the laboratory in the state police. And there was actually an inspection report from the American Board of Forensic Toxicology that recommended this duty be removed from the OCME. And I also would mention that transferring this oversight is actually implementing and following through on a recommendation the state police made in a 2020 joint chairman's report to address a toxicology backlog. And within that report, the state toxicologist actually submitted a letter just reiterating her support for the transfer as well. And I know Director Katz went through some ways that this would be beneficial for the state police. Some other ways are it will really improve lab efficiency and turnaround time, and will improve the lab's ability to recognize and respond to the rapidly changing array of drugs detected in Maryland drivers. So I think I'll end with the fact that this bill, it moves the oversight of the toxicology program from the state toxicologist in the OCME's office within MDH into a new fully funded toxicologist position at the Department of State Police. And just to reiterate what Director Katz said, because I think this is pretty important, is it allows both agencies to align their units with their mission. It'll allow the OCME to focus primarily on postmortem toxicology during death investigations, and will allow the Department of the State Police to focus on those antemortem toxicology related to impaired driving investigations. So the department fully supports this bill, and we would request that the committee return a favorable report. And with that, happy to take any questions.
Excellent. Thank you very much. I know we have at least one question. So Senator Hettleman, go ahead. You're up.
Thank you, Mr. Chairman. This seems to make a lot of sense to me, and I can't believe it's taken this long to be suggested. But I guess my question is how is this position already funded? Is there a transfer of a PIN, or kind of what other resources are needed to be able to make this really a full-fledged operation within MSP?
Yeah, there was a over-the-target request put in for this position. My understanding is that it is going to be in the budget. We also have contractual grant funds to try to get a contractual individual in the meantime. We're in the midst of those efforts. We have not yet secured an individual, but our hope is that we could secure an individual potentially with the contractual funds and then just move them straight into the permanent position when it is available.
And if I could ask a follow-up, is that, and do you feel like that's enough resources to do this?
Well, we thankfully got a number of resources in last year's supplemental budget for this purpose. So as was mentioned, we were requested to put in a report to the legislature about long-term solutions, because it should be known that Maryland State Police toxicology operations for at least blood alcohol and blood drug work, we're the only lab in the state that can provide that testing. So it has historically been a smaller unit, and we have expressed the importance of expanding that unit, both in size and also in sites. So we'll have operations at multiple laboratories as a contingency plan. And all of that was part of last year's supplemental budget, and we are in the process of carrying out those items. But the key to it all working is getting this permanent toxicologist and switching over the law from Department of Health to State Police.
Thank you.
Excellent. Thank you, Senator Hedelman. Senator Sidnor, you're up.
Thank you very much. And thank you all for your presentation. It's good to see you, Mr. Katz.
Good to see you.
Ms. Sheck, I had a question. When I was reading your testimony, and it said that OCME primarily focuses on post-mortem toxicology, and the state police, they on the anti-mortem toxicology. So I'm assuming with this change in law, I guess OCME disappears, and the state police, they'll focus on both post and anti-mortem toxicology?
No, so thanks for the question. It actually separates the two. So it allows the chief medical examiner's office to focus on the toxicology reports of deceased individuals. And it'll allow the state police to focus on the toxicology of those individuals that are still alive that have been pulled over for, forgive me, I don't know the exact term, driving under the influence of something.
Okay. And for some reason, I guess when I was can't recall whose testimony that I was reading, but it seemed to me that there was, I guess is there some backlog or something with the DUI toxicology being done? And if that's the case, again, I was wondering if it helps to transfer or not, rather than transfer the authority over, why not both state police and CME work in partnership?
So one thing,
jurisdiction.
Yeah, no, it's a great question. I think one thing that I should clarify is that only the state police is actually doing the DUI testing, and that's probably that's one of the things. So the post-mortem toxicologist out of the OCME was responsible for overseeing the program. So for approving the methods, approving the equipment, approving the personnel. But it has always been the state police who's actually performing the testing.
Gotcha. I appreciate that. So this essentially also, I guess, transfers any type of regulatory authority to the state police, so that okay, I see you shaking your head.
Yes.
So and just out of curiosity, with the regs that are currently in place, do you all see the state police just wholeheartedly just kind of, I guess the proposal will go out and just taking whatever is currently in place and just saying these are still going to be the rules, or how does that?
Yeah, we don't anticipate there being any major changes. I mean, we'll evaluate that, but it's a system that has worked. It just hasn't been. It just doesn't make sense how it's set up.
Gotcha. Okay, look, thank you.
Yeah, you're welcome.
Thank you, Senator Sidnor. Thank you very much. All right, looking around the room, any additional questions? With that, that'll conclude the testimony for Senate Bill 216. Thank you both very much.
Thank you.
Thank you.
All right, we'll now move on to Senate Bill 203. And we'll start off with Hartage. Janet, are you there? There you are.
Chairman Smith, if Denise could go first, I would appreciate that. I will address any follow-up questions that the committee has regarding how the Senate law is interplaying within with this bill and any changes. I'm an assistant attorney assigned.
Absolutely. Ms. Conway, floor is yours. Welcome.
Yes, thank you. Good afternoon, Chairman Smith, Vice Chair Wallstreicher, and committee members. I am Denise Conway, Deputy Executive Director of the Social Services Administration at the Maryland Department of Human Services. And I thank you for the opportunity to share the merits of Senate Bill 203. On May the 10th, 2021, the Children's Bureau notified the state that we must comply with Section 4755B of the Social Security Act, which requires that the status of every child in foster care be reviewed every 6 months. These hearings are required to determine the safety of the child, the continued appropriateness of the current placement, compliance with the current plan for the child and family, the status of addressing or mitigating the reasons for placement in foster care, and a projected date that the child may be returned home safely or placed for adoption or legal guardianship. In addition, for older youth who are expected to remain in foster care until adulthood, these review hearings are required to identify the opportunities for youth to engage in activities such as sleepovers with friends, social events, school-sponsored field trips, and scouting that normalize their lives and maintain their health, safety, and well-being, as well as assist in developing valuable life skills. The proposed amendments will ensure Maryland's compliance with federal statutes and regulations. Implementing federal mandates is critical for Maryland's federal funding retention and will more importantly ensure that we are regularly partnering with children, youth, and families around achieving lasting permanency. Thank you for your time and consideration. If you have any questions, I would be happy to answer them. And as you know, Janet Hartge from the Office of the Attorney General is also available to answer your more technical questions.
Excellent. Thank you, Ms. Conway and Ms. Hartke. Looking around the committee for questions. Seeing none. Thank you both very much. Oh, actually, almost got away. Senator West, you're up.
Thank you very much, Mr. Chairman. So I'm looking at the opposition of the Maryland Judicial Conference. Ms. Hartke, have you had a chance to take a look at that? You need to unmute.
I did. It wasn't allowing me to. I have had a chance to look at that, and thank you for the question. So if I can address their three concerns, I would like to take each of those in order. Their first concern is that where a court finds good cause to keep a case open after granting custody and guardianship, that the language may be insufficiently clear whether the department remains involved. So under our current law, if you didn't do anything, the department does not remain involved. The current statute provides that, and that's 3819.2, provides that once a court grants custody and guardianship to an individual, that at that point, that ends the department's obligation. And under our current law, the courts has the opportunity to still continue to hold review hearings without the department's involvement. So our current law makes clear that the department is out when a court grants custody and guardianship to an individual. We have many cases in child in need of assistance Senate proceedings where the department has custody for relative placement. That is a different situation than what's happening when custody and guardianship is granted under 3819.2. That's typically the end of the case. I realize that they raise a concern about if the department is not involved, whether or not the court would still have jurisdiction. The court has jurisdiction because we have these situations now and have had them. And the jurisdiction section provides that once a child is found SINA, that child then remains SINA until the court terminates jurisdiction. So it doesn't require the department to still be involved, and that's Court and Judicial Proceedings 3804B that continues the case until the child turns 21 unless the court specifically terminates jurisdiction. So if I can move on, did you have any questions regarding? Okay, then I'd like to move on to their next point about requiring that the child be seen if there are subsequent review hearings. So what happens, that law is actually in our current law. Right now, it's housed in 3823H1, but what we're doing is we are moving all of those provisions regarding custody and guardianship to the appropriate section of 3819.2 instead of having that housed under 3823. So that law came into effect in 2005, and that's our current law. When you have grant custody and guardianship, you have to see the child, and if you have subsequent review hearings, you have to see the child. And it came in because of the death of Sierra Jobs. It was the 2005 session, Senate Bill 746 was the original reason for that. So what happens if a court grants custody and guardianship to an individual? The department is not involved, so there would not be a department worker going out and seeing the child. And the death of Sierra Jobs was the reason that part of the statute was enacted in 2005 and has been in existence since that time and is a current requirement. So this would just be continuing that requirement. Is that okay? And then as to the last point, which is that we don't need the provisions set forth for APLA, that can be a matter of training. The federal government has said, yes, we do need it. The same sections contained above that have to be considered are also contained in that section. So that's 42 USC section 675 4B. And if you look at that section of the federal law, you'll see that the status must be reviewed every 6 months and what must be addressed. And in terms of what must be addressed, when you have a child who has another planned permanent living arrangement, which we say APLA, that then you must make those inquiries. We've taken that language directly from the federal statute, and we have been told that we need that language in there in order to continue to receive federal funding when we have an APLA child. Now, a child can't have a plan of APLA until they're 16, and that's within our statute, and that's complies with the federal law. So in terms of, a matter of training, it's just, if it's not in an order, if it's missing from an order, then we, don't get federal funding for that child. There has to be documentation that those findings are made. And so by including it in the statute, that will ensure that documentation is made. The other addition we made in there was the case plan, and that's required specifically by 42 USC 675 4B. We took out of the section the piece regarding permanent foster care and a yearly review. So every child must have a 6-month review. There hasn't been permanent foster care since 2005. House Bill 771, and that was then Chapter 576, eliminated permanent foster care as a permanency plan. And at that point, that's when APLA, another plan, permanent living arrangement, went into effect. It just wasn't eliminated from the other section. So there is no permanent foster care.
Thank you very much for your answer. It's certainly, you've thought about this deeply.
Well, I've done it for 34 years.
You've considered the objections. Might I just make one suggestion? Why don't you call Kelly O'Connor over in the Maryland Judicial Conference offices and talk about the objections and talk about your responses and see if you all can't come to consensus on this.
Okay.
My guess is you can. And it would help the committee to know that you all are in agreement on what should be done.
Okay.
Thanks.
Thank you.
Senator West, as always, you are the dispenser of sage advice. So thank you for that. With that, looking around the committee for additional questions. Seeing none, thank you all very much. Have a good one. Thank you. And with that, that'll end the hearing for Senate Bill 203. We'll now move on to Senate Bill 214. And we will go to Ms. Conway. You're up.
Good afternoon, Chairman Smith, Vice Chair Wallstreicher, and committee members. I am Denise Conway, Deputy Executive Director of the Social Services Administration at the Maryland Department of Human Services, and I thank you for the opportunity to share the merits of Senate Bill 214. This bill authorizes disclosure of reports or records concerning child abuse or neglect to certain school personnel and the director of a licensed child care facility or licensed child placement agency. The sharing of information ensures that children are protected across a multitude of disciplines serving children. Under existing statute, Human Services Article 1-202, Child Protective Services may disclose abuse reports and records with certain professionals within the education system, as well as licensed child care facilities and child placement agencies. Senate Bill 214 would expand the current practice to include the disclosure of alleged neglect. Dangers posed to children by individuals who engage in child neglect are just as significant as the dangers posed by individuals who commit child abuse. The proposed amendment would permit DHS to share neglect reports with these employers. The added provision for disclosure of child abuse or neglect reports or records to a director of a licensed child placement agency expands the protection for children. By permitting DHS to share information with the licensing agency so that the agency can take action to protect the child from maltreatment that may cause by any caregivers in the home. I thank you again for your time and consideration. And if you have any questions, I would be more than happy to answer them.
All right, thank you very much. Actually, I see one, I thought I saw a question. Senator Hedelman. Senator Hedelman, you are up.
Thank you very much, Mr. Chairman. So this is about a report. This is not post-investigation, correct?
This is about a report or a record.
Or a record. Okay, but so it's expanding the universe of entities to which you are allowed to share this information.
Yes. So currently we can share information related to abuse cases. And what we're asking is that you would be in agreement to share the same information related to neglect cases.
Okay, thank you.
So thank you, Senator Hedelman. Looking around the room for additional questions. Seeing none, with that, that'll conclude the hearing for Senate Bill 214. Thank you, Ms. Conway.
Thank you.
So we'll now move on to Senate Bill 198, and we'll take Secretary Green and then Secretary Brinkley. So Secretary Green, you're up first. Here you are. Good to see you. I think I got you. I think you're live, Mr. Secretary.
Very good. Yes, just making sure I was unmuted, Chairman. Thank you very much. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. For the record, my name is Robert Green. I'm the Secretary of the Department of Public Safety and Correctional Services. This bill extends the time frame by which an application for a death benefit may be submitted and authorized by the Secretary of the Department to award a death benefit if there is a finding of evidence that the death of the decedent results from an act committed against the decedent by another due to the nature and performance of the decedent's duties. Current law states that a death benefit to be paid for correctional officers who were killed or died in the performance of their duties must be in the performance of their duties at this time. Tragically, the department learned of the need to revisit the criteria of this benefit in June of 2021, when an individual was convicted of the killing of Correctional Officer Gregory Collins as he was driving home to his wife and then 5-month-old daughter after his shift at the Eastern Correctional Institute on June 4th, 2001, 20 years ago. The individual who killed Greg had a lengthy criminal history and was convicted of his murder this past June. After an extensive investigation by the Maryland State Police, it was found that Officer Collins' death was a direct result of the performance of his duties as a correctional officer. This killer was responding to a hit that had been placed out on him. For the work that he did at ECI, he sought him out, stalked him, and killed him for that reason. Once this evidence came to light, it was discovered that the article as written did not allow for the appropriate death benefit to be applied in this case. This bill proposes extending the 3-year window to eligible individuals when new evidence becomes available, indicating that a qualifying individual was killed at the hands of another because of his or her job performance, not just while they were on duty. With me today is Ms. Williams, the widow of Officer Collins, who will speak more about how this legislation will benefit families of correctional officers. I would respectfully request the committee to vote favorably upon Senate Bill 198, Chairman Smith.
Thank you, Secretary Green. We'll now move over to Secretary Brinkley, and then we'll go to Ms. Williams. Mr. Secretary.
Good afternoon, Mr. Chairman. Yes, I am unmuted. So it's good to see you. I think this is one of the first times or few times that I've appeared in front of JPR.
God bless you.
Yeah, I know. He has. Believe me, he has in many, many different ways. It's good to see you, the vice chair, and the other members of the committee. It's good to be here. I'm here to just answer any questions that you might have. When the secretary brought this concept up to me in September, thinking they could move forward with it, basically I took a look at some of the things that they laid out in front of me, and I said, we might have discretion, but the way I read the statute, we didn't really have a whole lot of wiggle room, but it was very narrow. And therefore, my recommendation was that they introduce a bill for your consideration, because there's a policy change to be made here with that 3-year limitation. I felt certain that you all would move forward favorably on this once this information came to light. But again, like I said, we decided to remove any discretion that was made and let the policy call go to the legislature. So I would encourage you to vote favorably on this bill. Something that comes to light 19 years later and then is adjudicated 20 years later. The family should not be penalized for any type of technicality in the law in that concept. Our mission is to ensure that our state employees are cared for, and when something comes up in the line of duty, we certainly want to extend the benefits that they're due. So I'm prepared to take any questions.
Excellent. Thank you, Mr. Secretary. And we'll now move on to, we'll take questions at the end of the panel. So if you could stick around, it'd be great. I'm busy, but we'll now move on to Ms. Williams. Is Ms. Williams up? I see you. There you are. Lena? Your mic is open, but we cannot see you.
Are you able to see me?
We are not.
Okay.
There you go.
Okay.
Perfect.
All right. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judiciary Proceeding Committee. My name is Lena Williams, the mother of Sydney Collins, widow of Officer Gregory Collins. For those who are not familiar with my story, just after midnight on June 4th, 2001, my husband left his job as a correctional officer at Eastern Correctional Institution. He never arrived home. When he had not arrived home, I began making phone calls to friends, family, and ultimately the police to report him missing. My husband was found murdered, and his killer was not arrested for another 18 years. It was not until a suspect was identified, arrested, and convicted that anyone understood he was killed because he had been a correctional officer. A hit was made upon him. Had this information been available at the time of Greg's death, my family would have been able to apply for the death benefit for individuals who were killed as a result of his job. By the time the information about Greg's case death came to light, the application period had expired. No one should have to experience the loss my daughter, my family, Greg's co-workers, and our friends went through. The availability of the death benefit serves the purpose of aiding those who have suffered the loss of a loved one. Throughout the years, the men and women of the Eastern Correctional Institution have looked out for Greg's family, and we certainly appreciate that they carry on his name and his memory. I now find myself in a position to give back by supporting a bill that is intended to provide assistance to people who find themselves in tragic situation. Allowing for this new evidence to extend the period of time for when loved ones may apply for the death benefit will serve and provide the assistance for those who unfortunately have lost their loved ones, who died in the hands of another solely because of the career they chose. In conclusion, I thank you for your time and ask that you provide a favorable report for Senate Bill 198.
Thank you, Ms. Williams, and thank you for taking the time to share your story. It means a lot. So Senator West, I see you, but we're going to wait to the end of the panel. We'll get you, and same thing with you, Senator Castley. Stuart Nathan, Mr. Nathan. There you are. Welcome. The floor is yours.
Thank you, Mr. Chair, members of the committee. My name is Stuart Nathan, Assistant Attorney General, Counsel to the Department of Public Safety and Correctional Services. I'm here primarily to answer any legal questions that may occur, but I would simply add that when we took a look at the current statute, we found that the tragic incident involving the death of Officer Collins was not covered by the current statute in the public safety article, basically for two reasons. One is because the current statute covers deaths or officers who are killed in the line of duty on or after January 1st, 2006, which would not have applied in this case where this tragic death occurred in 2001. And two, the language in the current statute that refers to a public safety official who was killed or died in the performance of duties, which has generally been interpreted to mean actually at the work site or directly connected close to the work site. So the proposed language in the bill would cover not only those who die in the performance of duties, but those, frankly, who died because of the performance of their duties, which would be the case with Officer Collins. And then I'd be happy to answer any questions.
I appreciate that. Thank you very much, Mr. Nathan. And we also have Rachel Sessa. She's here for questions as well, right? Do you want to provide testimony or just for questions? And let me unmute you.
Thank you, Mr. Chairman. Good afternoon. Here for questions only. Thank you so much.
All right, excellent. All right, well, I saw Senator West first, so we'll go with you, and then we'll go to Senator Castley. There.
not happening.
There you go.
Okay, thanks. Thank you, Mr. Chairman. So this is going to be interesting because Mr. Nathan and I were high school classmates. So here I get on the screen to have a colloquy with him. So it's going to be fun. And it's not going to be very long. In the law, dealing with statutes of limitations, there is a principle called the discovery rule. And frequently the law provides that statute of limitations don't start to run until the information that would give rise to the cause of action has been discovered. So as I understand this bill, it is creating a discovery rule to deal with this category of situations. Stuart, would you say that's correct? You got to unmute yourself.
No, give me a second. I'm modeling over. Here we go.
Yes, I think that is correct.
I thought that was an easy way to describe what's going on.
Yes, absolutely.
Thank you.
You're very efficient communicators. It must be from the years of the time. That's great. Like very quick answer. All right, Senator Castley, you're up next.
Sure. Looking on page 3, line 11 of the bill, for the folks who are answering questions for us, do we need to have the language that says on or after January 1, 2006? Can't we just leave this as a general bill for the next, well, hopefully we don't have any more of these, but just to apply to anybody where we discover, consistent with what Senator West was just saying, this is a sort of a general discovery rule bill. And is that phrase on or after January 1, 2006, is that legally necessary, someone feels? Thank you.
Mr. Nathan, you're up if you like.
I think the point is well taken. I think a general allowance for any additional evidence brought forward at any time would likely cover any possible scenario. So January 1st, 2006 was just used because that's the date that's in the current statute. But to broaden it, and again, it's left up to the discretion of the Secretary of Public Safety to take a look at that additional evidence. So frankly, I would not have a problem with removing just that one clause.
Thank you. No further questions. Thank you, Mr. Chairman.
Excellent. Thank you very much, Senator Castley. All right, looking around the room for additional questions, seeing none, that will conclude the hearing for Senate Bill 198. Thank you all very much. We'll now move on to Senate Bill 212, and we'll start off with Secretary Green. Well, I would say, let me ask you to unmute you. There you go.
There we go. Thank you
Sandy,
again.
I'm sorry, Mr. Secretary. Sandy, I think that is this a part of the presentation?
It is at the third paragraph in about 30 seconds in, and then Perfect. It can be removed.
Excellent. All right, just making sure. Thank you.
Thank you, Chairman. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. Again, for the record, my name is Robert Green. I'm the Secretary of the Department of Public Safety and Correctional Services. This is the third year we've brought this bill before you, which seeks to reduce the minimum age an individual can apply to be a correctional officer with the department from the age of 21 to 19. As you will see on the illustration before you, the visual we brought before you today shows 37 states across the nation hire correctional officers below the age of 21. 32 states hire correctional officers at or below the age of 19. Thank you for the illustration, and you may take it down if you like. Let's also be clear as to what we've also done to this point to increase recruitment across our department. In 2020 and 2021, we have hired a total of 954 correctional officers, more than any of the previous 6 years. We've dramatically increased salaries in our state since July of 2018 by more than 20%, and we are very competitive across our state and the country. We've provided longevity pay for individuals with over 20 years of service and numerous other technical skills incentives to this classification. Changing the hiring age to 19 will increase the pool of applicants, but it will not lower the bar. We focus on integrity, not age. You will hear from two officers here today who were hired at the age of 18 and 19 as part of our witness testimony. Changing the hiring age to 19 allows the department to be considered by career-minded individuals who are seeking to work in public service and who want to remain in their local communities, specifically community colleges, to target with this legislation. Not one thing about this bill changes the comprehensive hiring practices already in place. This simply changes the age at which an individual can apply. If I may, we're not asking you to consider the unproven or the extraordinary. We are asking for the ability to do that which has become mainstream in today's corrections profession. I would very respectfully request consideration and your favorable review of this bill.
And thank you very much, Mr. Secretary. We'll now move on to Ms. Vasquez. Is she up? There you are. You're up.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, and members of the committee. My name is Sasha Vasquez Gonzalez, and I'm the Acting Deputy Secretary of Administration for the department. I joined the department in November 2018 as the Executive Director for Human Resources. During my time in HR, my team and the entire department implemented several significant changes to the recruitment and hiring process. Under my tenure and as directed by Secretary Green, we implemented a process where interested candidates are able to apply, receive an orientation, do their interview, writing sample, and many left with a conditional offer of employment. Candidates that were not able to participate or are not able to participate of the one-day hire events may still schedule their interview and receive a conditional offer within a couple of days instead of months. We were able to pivot tactics at the onset of the pandemic that allow us to continue most processes virtually without stopping the hiring of correctional officers at an astronomical rate. During fiscal year 2020, the department has submitted monthly reports to the budget committees on this continuing efforts, and in fiscal year 2021, switched to quarterly reports highlighting our accomplishments. I am very proud of the strides we've made. However, despite these efforts, the department has experienced a 73% decrease in the total number of correctional officers' applications received over the past 5 years. It is imperative that we take action to widen our pool of potential candidates. We have seen interest in this age group who have wanted to pursue a career with our agency and likely have accepted jobs at other agencies or local correctional facilities who can hire at 18 or 19 years of age. Senate Bill 212 will add a critical tool to our tool belt in that it will allow us to engage qualified candidates who were previously unavailable exclusively due to their age. The Department of Public Safety and Correctional Services respectfully request that the committee to vote favorably on Senate Bill 212. Thank you.
Excellent. Thank you very much, Ms. Vasquez. We'll now move on to Mr. Ward.
I don't have him in the waiting room, so I've alerted public safety. So if they can get him in, I will admit him.
Okay, excellent. Then we'll move on to Ms. Dortch. April, is April here?
So she is in, but it appears that she only has video access.
Excellent. All right, well, then we'll move on to the unfavorably opposition panel, and we'll just hear from Ms. Gilmore first, and we'll toggle back if the other two witnesses can make it. So is Ms. Gilmore in?
She does not appear to be in either.
Got it. All right, now I see that. Okay, is anyone else here? Sorry, I guess we'll give them a moment. Do they have a moment? Are they still in the waiting room?
They are not in the waiting room.
Okay, excellent. Well, then we'll turn it over to the committee for questions. Senator West, and if the witnesses come in, we'll get to them afterwards. So Senator West, you're up.
There we go. I think I got unmuted. So as long as we have no opponents, there is a written testimony from the from the AFSCME. And I think it's fair to summarize the testimony saying that you shouldn't hire, if you're short of staff, you shouldn't hire 18 and 19-year-olds or 19 and 20-year-olds. Instead, you should pay the people more. And if you pay them a lot more, then you get more applicants to fill the positions. That's not unexpected, but I was interested in a factual statement in the testimony. They said Maryland recently tried hiring below age 21 for its cadet program. Although there were over 1,000 applicants, only 3 were hired and none have made it to becoming a correctional officer. So can one of the proponents for the bill explain how this relates to what this bill would seek to do, which is to enable the department to hire correctional officers under the age of 21. If it doesn't succeed with the cadets, why would it be more successful with respect to correctional officers?
Start off with either Mr. Secretary, defer to you, or Ms. Sessa. So
certainly. And I would tell you the cadet program, you have individuals that are, especially in our rural communities, they're seeking full-time employment. They're not seeking limited employment. They're seeking a career. They're seeking to be part of our narrative. And again, this is not been anything that we have done simply because we are seeking to hire more people. It's part of a continuing narrative, multiple things that we have done. I have the ability to meet with individuals that sit in my chair from across the entire country. And again, 32 states have engaged this. I engaged this the first time well prior to the pandemic as an opportunity to, again, create yet another path center to do that. I am aware of individuals that absolutely did start as cadets and have been hired into our system. That is at a much lower salary. An individual wants to get into the department, wants to create a path, a career, create the ability to specialize and move forward within our department. This was changed in 2007 and 2008. And had we had our 2 witnesses here today, both of them very successful correctional officers who applied at the age of 18 and 19 and moved forward in this department.
Okay, so is it fair to say that your view is that if these applicants had been had a full correctional officer position available to them instead of just the cadet position, that many more of them would have been hired in the department?
Absolutely, Senator.
Okay, great. Thank you so much.
So thank you, Senator West. And he said, I see that April's here, but her audio is still connecting. So I'm just going to go over to Senator Watson for his questions, and then we'll see if she's connected up.
And also Denise Gilmore is here. She's joined.
Okay, excellent. All right, let's do this. Senator Watson, let's go ahead and you grab your question, and then we'll go to Ms. Gilmore.
Unmute. All right, thank you, Mr. Chair. My question is for the Secretary. Good to see you, Secretary Green. So did I hear you correctly that your desire to do this is not a result of the decrease of staff with respect to the pandemic?
No, Senator. I've been pursuing this for 3 years since my arrival here at the state. It is not solely for that reason. It's to increase the pathways that we've created and expand upon them. Again, just one additional pathway to many others we have in place.
And in the graphic you show with the states that do allow for 18 and 19-year-olds, in those states that have that age requirement, are there any activities within the system that that age group is restricted from doing?
I'm unaware state by state any activities that they are restricted from doing, but we'd be pleased to get that information to you.
Okay, because I'm curious to know if an 18-year-old has the same rights and responsibilities as a 21-plus-year-old upon hire. The other thing is, of course, you know me from my days on the judiciary. So there's been plenty of emails where I hear about assaults on correctional officers and those types of things. Do you have any metrics at all that could let me be rest assured that 18, 19-year-olds are not impacted more so than those of 21-year-olds and up?
Yes, sir, we do. And we've looked at some of our data of investigations within the system. It's not a lowering of the standard to a 19-year-old. It's allowing a 19-year-old to come up to this standard of application and standard of background. We'd be happy to share with you some data around that. That was an assertion previously, and we did not find that to be factual.
I see. And, my hesitation is questioning the maturity level, the wherewithal of somebody at that young age to be put in that type of environment. And we all know what happens in that type of environment, the pressure, the stress. This is not an everyday job. This job requires, acute mental faculties that are always on guard and always on target. So I do have some concerns and reservations about lowering that criteria, but I look forward to getting some additional information from you.
Thank you, Senator.
Thank you.
So thank you very much, Senator Watson. So I see we have Mr. Ward and Denise. I see you, Ms. Gilmore, she's up. So we'll go with Mr. Ward. Evan, you're up first, and then we'll work our way down. Mr. Ward, does your camera work? There you are. Excellent.
Sorry, sir. We're having some technical difficulties on my end here. I think I have it up and running now, sir.
You're up. Yeah, you're good.
Just briefly, good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is Evan Ward. I have been a correctional officer for the Department of Public Safety and Correctional Services since March of 2004, when I was hired as a 19-year-old. At the time, I was enrolled at the University of Maryland Eastern Shore. I was attending classes during the day and working at Langford Cisco at night. I heard that Eastern Correctional Institution was lowering the hiring age from 21 to 18. It's not that I couldn't do the college work. It was just that sitting in the classroom all day wasn't for me. Even during high school, I had a summer job working with my uncle on a crabbing boat. During the school year, I helped my dad with his lawn service after school if I wasn't participating in sports. I was a worker. Being busy and on the move was something that I enjoyed. I felt ready to work, go out there, make money, and not just sit in a classroom all day. I wanted to support myself. And to be honest, that's when I made the best decision of my professional life and went and took the test to become a correctional officer. Later, I was offered a job and I accepted. I was hired as a 19-year-old. To me, this just wasn't a job. It was an opportunity for a career. The department offered stability, a salary, health benefits, and a retirement. Even as a 19-year-old, I knew how important those things were. This opportunity was very rare for anyone living on the Eastern Shore, especially someone without a college degree. That was true then, and I still believe it to be true today. On March 3rd of this year, I will reach my 18 years with the department. During this time, I've progressed through the ranks from correctional officer trainee to my current rank of lieutenant, which I've held since the age of 25. Along the way, I've been a field training officer, firearms instructor, tactical response officer, and an administrative remedy coordinator, just to name a few. My career with the department has been a blessing to me and my family, and I am thankful that I've been given the opportunity to be here today to share my story. In conclusion, I support Senate Bill 212 for the reasons presented today and a request of favorable report.
And thank you very much, Mr. Ward. And I'm glad we got you squeezed in here. We still have one more, Denise, Ms. Gilmore, before we go to you, just for switch over to the opposition panel, we've got one more proponent. So we got April up? Do we have good comms? Yes, there we are. How are you?
I'm pretty good. And yourself?
Very good. The floor is yours. Thank you for joining us.
Can you guys hear me clearly? Because I was having some difficulties as well.
We can.
Okay, good. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is Captain April Dorch Battle, and I have been an employee of the Department of Public Safety and Correctional Services since June 1st, 2004, when I entered the academy as an 18-year-old. I joined the department because they were one of the few employers who would hire an 18-year-old who was not ready for college, but who was ready to begin a career, not just a job. As a new employee, I knew the department offered a 20-year retirement and so many different opportunities. When I joined the department, I benefited from the guidance of officers who with more time on who offered networking and support. As a senior officer now, I'm excited to meet new officers regardless of age to offer the same type of support. I'm happy to support Senate Bill 212 because I took forward the motivation, energy, and ideas new officers bring to the department, especially the energy, as the job requires a lot of walking and standing. Senate Bill 212 would allow a larger pool of applicants to apply. These applicants will be vetted through a process that is similar to the one I completed. Based on my experiences with this process, I believe the hiring process and academy training do a good job screening individuals who may not possess the integrity to perform the job of a CO. I support Senate Bill 212 because it will cut back on staff shortages and overtime. With over 17 years of experience with the Division of Correction and the department, I am familiar with working overtime and the sacrifices I and all officers make to ensure appropriate coverage on every shift. Expanding the pool of applicants is expected to increase the number of applicants and result in continuous hiring. Finally, I support Bill 212 because the department's ability to hire 18 opened the door for me 18 years ago, resulting in the start of my career and allowing me to grow, thrive with the department. In conclusion, I support Senate Bill 212 for the reasons presented today, and I request a favorable committee report.
Excellent. Thank you very much. I'm glad we were able to get you in. All right. Now that completes the testimony for the proponents. We'll switch over to the opposition panel. So Ms. Gilmore, finally, at last, we are able to take your testimony.
Thank you so much. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. For the record, my name is Denise Gilmore, and I'm a field director with AFSCME Council 3. We represent the correctional officers who work for the state of Maryland, and we oppose Senate Bill 212. As this is the third year that we are opposing this bill, I'll be brief in my comments today and refer you to our written testimony where we certainly go into more details about why we oppose attempts to lower the minimum age requirement for our state correctional officers. But simply put, we do not believe teenagers or even 20-year-olds have the life experience that is needed to respond to the many challenges correctional officers face in a state prison setting. I want to quickly summarize 3 points. First, we have tried this before. In 2002, the age was lowered from 21 to 19, and it did not work very well because of the many reasons we state in our written testimony. In 2007, the age was raised again to 21, where it is today. The attempts to hire cadets recently has been mentioned under the age of 21. Very few have been hired on as actual correctional officers. While they're in this cadet stage, they don't have the custody capabilities that full correctional officers do. So their utility is somewhat limited, which is why we question if overtime or staffing will be solved by going that route. Second, while some Maryland counties may lower the age requirement of correctional officers, the national standard, the vast majority do still have age 21 or older as the minimum requirement for correctional officers. And finally, we believe that the best way to improve staffing is to increase compensation, benefits, and incentives that correctional officers receive. And we hope to keep working with you all in the department to do that. There absolutely is a crisis in our state prisons for staffing right now, and our members know that better than anyone. We want to focus on solutions that will work, not further endanger folks. For these reasons, we urge the committee to provide an unfavorable report on SB 212. Thank you for the opportunity to testify.
Thank you very much. I'm glad we were able to get you in. Looking around the room for questions. Seeing no questions, that will conclude the hearing for Senate Bill 212 and our bill hearings for the day. Thank you all very much. And Senator Watson, welcome to JPR. You've completed the first hearing, albeit remotely on campus, but through Zoom. And look, we'll see you all tomorrow. So have a good evening. Thanks a lot.